Good morning, if you're in Europe. Thank you very much for your for joining this webinar hosted by Red Notice Monitor. As you'll see from the advert, Baroness Kennedy was meant to be chairing this, but she has unfortunately been called away to deal with another matter in the House of Lords. So my name is Ben Keith. I'm a barrister at Harth and Andrews Hill, and I'm one of the editors of the Interpol blog Red Notice Monitor. As an excellent replacement for Baroness Kennedy, we have Luke de Pulford from the Interparliamentary Alliance on China, and he's going to speak in her place. And I have been moved up or down into chair, whichever way you like to think about it. The topics we're going to look at today are the interaction between Chinese transnational oppression and Interpol, and how that has impacted upon individuals and mainly on the Uyghurs, but we're also going to have a little examination of what's been happening in relation to sanctions and Hong Kong. So you may have seen recently the recent documentary on CBS 60 Minutes in the US was released on Sunday, and one of the criticisms that we made on that documentary of Interpol was its failure to tackle transnational oppression, and particularly those issues from Russia, China, UAE, and Turkey. In response to that, rather surprisingly, the General Secretary of Interpol, Jürgen Stock, effectively said that he was not so concerned with misbehavior, and they didn't like to discipline any particular jurisdictions or countries because it meant that there was no police-to-police cooperation. If you believe in human rights, then that's, in my opinion, a pretty terrible way to behave. And we hope in the future, when there's a new Secretary General, that there might be a change of attitude. But what we thought we'd do today is to bring together some leading lights in relation to analysis of Chinese human rights, and in particular the transnational oppression aimed at the Uyghurs. First to speak is Rahima Mahmut. Rahima is the UK director of the World Uyghur Congress and leads the campaign for them in the United Kingdom. She's also the executive director of Stop Uyghur Genocide, and has vast experience, unfortunately, of Chinese transnational oppression, not just against her, but against friends, family, and colleagues. So, Rahima, I'm going to hand over to you to give us a bit of background about the problems the Uyghurs have faced in China, and then how that repression and genocide has been exported abroad.
Thank you. Thank you for that kind introduction. Since the occupation and the colonization, Uyghur people, our rights and freedoms have been violated for a long time, but especially since the occupation by the Chinese Communist Party, the CCP. And throughout my life, our language has been eroded over decades, and our cultural and religious rights were under attack, even when I was growing up. On February 5th, 1997, a date which we commemorate each year, military forces were used against peaceful protesters in my hometown of Hulja, killing hundreds and arresting thousands. This event made me realize that it was no longer safe for me and my son. I left my homeland soon after in 2000. But life for my fellow Uyghurs back home has deteriorated rapidly since I left. And in 2009, the Urumqi massacre took place. And during this event, the Chinese government used violent clashes between police and protesters to justify an extended brutal crackdown on the Uyghurs. Following the protests, the government gave the green light for extrajudicial arrests and killings. Men and boys were publicly beaten, and others were rounded up into buses, trucks, driven away, and never seen again. And the Urumqi massacre proved to be an early warning sign of what was to come for my people, and signaled a dramatic gear shift in the way we were treated by the regime. And the building persecution, violence, and repression, coupled with relative silence from the international community, has led us to where we are today. And since 2017, Uyghur people have been facing genocide. And there is now widespread and extreme cultural and religious repression across the region. Uyghurs fear imprisonment for the most basic form of expression, including praying, men growing long beards, or owning a Quran. Our sacred cultural practices have been banned, our religious sites bulldozed, and our language censored. The region itself has been turned into an open-air prison covered by a network of high-tech surveillance equipment and checkpoints. State-mandated policies have seen cadres moved into the homes of Uyghurs, with many women forced to share their beds with the male officials. Children have been taken from their homes and placed in state-run orphanages where they are indoctrinated. The Chinese government is attempting to biologically and socially engineer away future generations through forced inter-ethnic marriages, mass sterilization, and abortions. These policies are designed to deliberately reduce the Uyghur population, even though we make up less than 2% of the total Chinese population. It is on this point that the Independent Uyghur Tribunal found the Chinese government guilty of perpetrating genocide against my people. And we estimate about 3 million, up to 3 million Uyghurs have been detained in the so-called re-education camps, but we call it concentration camps. And I have translated the testimonies of many men and women that survived these places. They spoke of food and sleep deprivation, routine torture, and systematic rape. As is the case with every genocide, what we are facing is an existential, almost unthinkable threat. And yet its reverberations are deeply personal to every Uyghur. We each have our own story, our own grave, and our own struggle. I have myself been unable to speak to my own family since January 2017. I used to regularly call my siblings. Then in late 2016, they stopped answering the phone. After trying many times, finally in January 2017, I managed to speak to my brother, who told me when I asked why no one is answering my phone call, said they did the right thing and please leave us in God's hands. And then after 6 years, not heard from anyone, although I tried different ways to find information, but because of the transnational repression and the way how the Chinese government persecute people who try to help people like me. And in April last year, I received the heartbreaking news of my eldest sister's passing. And I also learned that my eldest brother endured over 2 years across 3 concentration camps and was eventually released due to severe health complications. And the person who conveyed this information advised me not to contact them for their safety. So this is the situation that is just not my story, but this is so common, the thousands and Uyghurs are living in exile. This is one of the most painful things that either we know our family members being taken in and no information, or even when we learn or what happened, or often is a very long-term prison sentence, sometimes like life imprisonment, or we hear about our relatives or families' death few months after or few years later. So people living in exile, also not free, even though, for example, like myself, I'm living in this country, campaigning for the Uyghur people, for my people, but people, they're not even like living in this country, they're not contacting me. And some people came forward and told me that they were called by the state security police, approached by the state security police, and asking them to monitor my work and report what is happening in this country. So the situation is dire, and this is ongoing. I'm not going to say too much about the transnational repression part. I'm sure my other colleagues who can cover more about it. But for every Uyghurs, we are living, whether we are living in Europe, in Turkey, or the worst is the ones that living in Central Asia, neighboring countries like Kazakhstan and Kyrgyzstan. The threat is so real that the Chinese police can go to that country and snatch them and take them back to the Uyghur region. So this is the situation that has been happening for many, many years and really needs international support and help and attention, and condemn from the government and take real action to impose sanctions and many other actions. Thank you.
Thank you, Rahima. It's always very troubling to hear what's happened, and particularly moving to hear first-hand accounts. And I know that you've heard an awful lot of very harrowing stories. I'm sure we'll come back to the end to answer some questions. But one thing I should have said by way of housekeeping is that if any attendees have questions to answer, we will take them at the end. Or if you have a question halfway through, then please post it in the Q&A box, which is at the bottom of your screen, and I will decide whether it's appropriate to answer that midway through the seminar or towards the end. Our next speaker is Laura Harth, who is the campaign director at Safeguard Defenders, the NGO who have been fighting tirelessly to expose Chinese transnational repression. In particular, some of their reports deal with Interpol. Some of their reports deal with the use of Chinese police officers stationed abroad, which is a particularly worrying development, which has been around for a long time, but only really light by some of their very good work. Laura is going to build on what Rahima has explained to us about what happened to the Uyghurs and explain how China exports some of those practices abroad and threatens people in foreign states.
Yes, thank you, Ben, and thank you, Rahima, as always, for being so courageous to stand up, tell the story of your people, tell the story of your family. I think we all owe you, a lot of gratitude for continuing to do that, notwithstanding what's been happening in Xinjiang and also what's been happening to you and many Uyghurs around the world. As you hinted at, I'll talk about transnational repression. So when the repressive acts of the Chinese government, the Chinese authorities, do not remain inside China, but increasingly reach across borders and really around the world. Now, when we talk about transnational repression, as of today, there's not really an internationally, I would say, accepted definition of the concept. But a recent resolution adopted by the Parliamentary Assembly of the Council of Europe in June 2023, and to which 48 states are a member, describes 4 main methods of transnational repression. It talks about direct attacks by which an origin state carries out a targeted physical attack against an individual abroad, such as assassinations, assaults, enforced disappearances, physical intimidation, or violent forced rendition. A second method is that of co-opting other countries to act against a target using detention, unlawful deportation, and other types of forced rendition. This method, according to the Parliamentary Assembly, notably includes misuse of Interpol red notices, extradition proceedings, and other forms of interstate legal assistance. The third method concerns impediments to mobility, such as passport cancellation and denial of consular services, thus preventing the target from traveling or causing them to be detained. And fourth, threats from a distance, including online intimidation or surveillance, and coercion by proxy, in which a person's family, loved one, or business partner is threatened, imprisoned, or otherwise targeted. Now, each of these methods outlined in the resolution by the Parliamentary Assembly of the Council of Europe can be discerned in the People's Republic of China's transnational repression tactics to intimidate, silence, discredit, or otherwise coerce members of the diaspora abroad. It must be said that they are not exclusively targeting the Uyghur diaspora, although it is very clear that many of them, such as Rahima, have really borne the brunt of it through the brutal crackdown, mass internment, and genocide of their family members back in China. In its 2022 assessment of the situation in Xinjiang, the Office of the High Commissioner for Human Rights stated that over the past few years, credible information has been received about members of the Uyghur community living abroad in several countries, having been forcibly returned or being placed at risk of forcible return to China in breach of the prohibition under international law of refoulement. The UN human rights mechanisms, including the UN Committee on the Elimination of Racial Discrimination, as well as the special procedures, have expressed concerns about reports of forcible return of Uyghurs to China and have recalled the human rights and refugee law obligations of both China and third countries in such circumstances. In this context, the Office of the High Commissioner is also aware of dozens of Uyghurs living in third countries whose passports have expired and who have experienced difficulties in renewing their documents, including due to fear of reprisals or fear of being forcibly returned to China. These patterns of intimidations, threats, and reprisals are generally credible and are likely to have caused and continue to cause a serious chilling effect on these communities' rights to freedom of expression, privacy, physical integrity, and family life, and in consequence, inhibit the flow of information on the situation in the Uyghur region. So this is from the 2022 assessment of the Office of the High Commissioner. Now, again, beyond the Uyghur diaspora, beyond those individuals the PRC considers to be Chinese nationals, and we know they have a very broad concept of who a Chinese national is, it's also very important to highlight that more and more we see these tactics being used also against outspoken critics of the regime with other nationalities, including in the United Kingdom, including, I would say, sitting members of parliament, such as Baroness Kennedy herself, but also Luc de Pulford, who's present in this panel. Now, the overall aim of the CCP, the Chinese Communist Party, is one of establishing a repressive regime of control far beyond its borders and create an international environment where it can kind of set and enforce the so-called tell the China story well narrative everywhere, as it seeks to rewrite the international rules-based order and undermine the universality of human rights. Now, discussing the whole array of tactics employed by the PRC against the Uyghur and other diasporas would take too much time, so I'll focus briefly on one of its most extreme forms, when the authorities, the Chinese authorities, reach across their borders to coerce individuals to return to China for prosecution. The best way to describe their methodology is really provided by their own written legal interpretation to Article 52 of the National Supervision Law from 2018. They essentially use 5 different forms. I'll discuss 4 of them, most of which are in direct violation of international human rights law, in particular the principle of non-refoulement and the territorial and judicial sovereignty of other nations. The first one, most traditional, extradition, when we have formal cooperation between 2 states on the basis of bilateral extradition treaties or multilateral judicial cooperation instruments. Extradition is usually subject to judicial safeguards and judicial overview. Now, these processes often follow arrests on the basis of an Interpol red notice or maybe a diffusion. The second method is repatriation. This is one China really likes to use. They use or abuse immigration law in cooperation with third country authorities to return an individual. Using that method, it's easier because they can circumvent judicial safeguards that would be afforded under formal extradition proceedings, and thus also often the principle of non-refoulement, despite the fact that that is guaranteed under the UN Convention on Refugees. Now, this method is likely or may have been used, for example, in the case of 4 Uyghurs held in Saudi Arabia, among whom a girl who was only 13 years old at the time of her disappearance. It's also a tactic that's very frequently used, as Rahima already hinted at, across Central and Southeast Asia, as well as certain parts of Latin America, Africa, and the MENA region. Now, it's important to highlight how both extradition and repatriation with cooperation from other states directly contravene the Office of the High Commissioner's recommendation in its August 2022 assessment on the situation in Xinjiang, when it stated that the office recommends to the international community that states should further refrain from returning members of Uyghur and other predominantly Muslim minorities to China who are at risk of refoulement. The fourth method is called persuasion to return. This is the CCP's favorite because it's kind of easiest. It's very difficult for national authorities to detect or counteract. And it concerns methods employed to convince a target, so-called coerce a target, to surrender and return to China outside any judicial proceedings. Methods include online threats and harassment, surveillance, and collective punishment of family members in China, threats, surveillance, and harassment of a target directly abroad by Chinese undercover agents, embassy or consular personnel, and proxies for the Chinese authorities, such as the individuals linked to the so-called overseas police service centers, hired private investigators, but also members of the diaspora themselves who may have been coerced into spying and reporting to Chinese authorities, for example, through threats to their family members or other. Now, the fifth method is a dual one, maybe the most concerning one. And again, I wish to highlight this is an official legal written interpretation by a Chinese authority, the Chinese authority in charge of overseeing all so-called international fugitive recovery operations. So this fifth method is A, kidnapping, or B, trapping or luring the targeted individual to a country, the international high seas, international airspace, or a third country with an extradition treaty from where it is easier to extradite or repatriate the individual. Abuse of international police cooperation mechanisms such as Interpol play a key role in this strategy, as has been, for example, the case for Uyghur human rights defender Idris Hassan, who has been languishing in a Moroccan jail for 2.5 years now, on the basis of a red notice Interpol itself defined as abusive following his arrest in July 2021. Now, I know Alexis from MENA Rights Group will talk more about his case, so I won't go into detail, but I really must highlight how Interpol not only clearly failed in its duty to review the grounds for the red notice when it was requested in 2017, but also, frankly, failed to do anything to try and rectify the situation after his arrest. It's really a cautionary tale of what can and should not be as easily dismissed as Interpol's chief did in CBS's recent 60 Minutes interview Ben talked about, when he said mistakes are made both by national authorities and Interpol. This is not acceptable. These are people's lives and have a very real impact on their physical and mental integrity. Now, I must add that anecdotal evidence since Idris's case does suggest there may be some improvement when it comes to Interpol's and democratic nations' dealings with Chinese requests. And I do wish to commend Interpol on, for example, their proactive statement that it would not accept requests for red notices on the exiled activists wanted by Hong Kong authorities as issued in 2023. However, legal uncertainty often remains for potential targets. Now, in conclusion, it's also very important to highlight that the PRC is continuously on the lookout for alternatives to exploit. A striking example is a memorandum signed between the body that authored the written legal interpretation that formally includes kidnapping as a legitimate means to return individuals and the UN Office on Drugs and Crime. Under that memorandum, China has been actively enabled to establish other channels of bilateral police cooperation mechanisms. Luckily, during China's most recent Universal Periodic Review, or UPR, at the UN, multiple countries have raised its record of transnational repression. Unfortunately, only a small number of democracies so far have actually actively started implementing countermeasures, including dedicated points of contact for targeted individuals to report. More must and can be done at all levels, national, regional and multilateral, including within international bodies such as Interpol or UNODC, to counter this continuous threat. And I do want to encourage anyone who is or has been the target of any of the methods I described to visit Safeguard Defender's website and download our pilot reporting guide, which is also available in Uyghur, and be on the lookout for our dedicated comprehensive resource center on countering extraditions to China, which will be available next week. Thank you.
Thank you, Laura. I think I just wanted to actually add one thing to sort of just draw a couple of those threads together, is that we know that the China's use of Interpol is often quite different to other states, because often they use Interpol not to extradite people, but to find them. And then once they've found them using the red notice or the diffusion, either use, particularly in Western states, use the police who are stationed in those states, or the other methods of transnational repression, including kidnapping, threats, and persuasion. But it is, unfortunately, that misuse of Interpol where they find individuals that often starts off the chain of events of the Chinese transnational repression. And so we're going to turn to Alexis Thiry. I hope I pronounced your surname correctly, who is from MENA Rights, who are not traditionally an NGO who deal that much with China. So, Alexis, could you just explain how MENA Rights became involved in Idris Hassan's case, and what your background is?
Thank you, Ben. No, thank you, Ben, and the Red Notice Monitor for convening this important webinar on such an important topic. I work as a legal advisor at MENA Rights Group. We are a small Geneva-based organization defending and promoting human rights across the Middle East and North Africa region. In recent years, we had an increasing number of extradition or cases that would fall under transnational repression, but mostly across Arab League member states. So as you said, it was very unusual for us to work on the case of Idris, because usually it's cases involving two member states of the Arab League. We began working on the case of Idris Hassan shortly after it was revealed, or shortly after he was arrested in July 2021, when we heard disturbing news that the Uyghur had been arrested in Casablanca. It was actually reported in Moroccan media, in French and Arabic, that he was arrested on the basis of a red notice circulated by Interpol at the request of China, and that he was wanted for terrorism. I want to say a few words about Idris Hassan. So Idris is 35 years old. He's married and the father of 3 children. He's a Chinese citizen of Muslim faith. He belongs to the Uyghur ethnic group. He and his family come from Korla, the Xinjiang region, where widespread and systematic violations have been reported. We discussed this previously. In 2012, he immigrated to Turkey, where he worked as a computer engineer. He lived there with his family. In Turkey, he was helping his community with translation work with the local authorities. He was granted not so long ago, not so long before he moved he went to Morocco, but he was granted a humanitarian visa by the Turkish authority. But despite that, he felt he was no longer safe in Turkey. So that's one of the reasons why on the 19th of July 2021, he boarded a plane for Casablanca, hoping to reach a safe country later on. He was arrested in Casablanca on the basis of a red notice circulated by Interpol. The red notice, and Laura, you mentioned it before, was issued in 2017. In the document, the Chinese authorities mentioned and they stated that Idris had joined the East Turkestan Islamic Movement, ETIM. It states as well that there was an arrest warrant for Idris issued in 2014. And that he's wanted for actively leading or participating in terrorist organizations on the basis of Article 120 of the Chinese Criminal Code. So we quickly began to work on the case. We had very mixed feelings about the odds of the extradition proceedings in Morocco. We expected that Morocco would be under pressure from international pressure to drop the extradition proceedings. At the same time, we also knew that Morocco and China had recently ratified an extradition treaty. But our fears began to grow when the Moroccan authorities decided to ignore Interpol's decisions to suspend and later on cancel the red notice in August 2021. A few months before, this is in reference to what I explained before, there was the case of a Saudi national who was extradited from Morocco to Saudi Arabia, despite the issuance of interim measures requested by the Committee Against Torture, the CAT, that we had requested. The process was very swift. The process was very quick. He was extradited in the middle of the night. So on the basis of that experience, we really wanted to do everything we could to make sure that Idris was not going to suffer like a similar fate. So we quickly began to work on a request for interim measures addressed to the CAT, the Committee Against Torture. We had a very good understanding of Morocco's extradition proceedings, but we had very little information about the human rights situation in China. Of course, we are reading the news, we are aware, but such cases have to be documented. It's one thing to explain the general situation in China, but it's another to assess, the personal risks, faced by the requested person. And that's how we began to join our forces with Safeguard Defenders to build a strong case. And the Moroccan legal team that did an amazing work defending Idris was facing a similar challenge. They knew about the proceedings in Morocco, but they needed, relevant and up-to-date information about China, the requesting state. So I will tell you a little bit more about the extradition proceedings in Morocco. In Morocco, it's the Court of Cassation that has jurisdiction on extradition cases. Immediately after he was arrested, Idris was brought before the public prosecutor of the Casablanca Court of First Instance. And on that, without a lawyer, because Moroccan law actually doesn't provide legal assistance at this stage of the proceedings. On that occasion, during the hearing with the prosecutor, Idris refused the extradition and he said he would be executed should he be sent back to China. He was transferred to the Tiflet prison. He's still in Tiflet prison, by the way, while awaiting a decision from the Court of Cassation of Rabat. Shortly after, he applied for asylum at the UNHCR in Rabat. And then on the 28th of July, 2021, the public prosecutor at the Court of Cassation submitted an extradition request to the president of the Court of Cassation. And that's more or less at the same time in this context that Interpol suspended and canceled the red notice against Idris Hassan on the ground that it does not comply with Article 2 and 3 of the Constitution of Interpol. And this decision was actually taken by the Notice and Diffusion Task Force, the NDTF. And at that time, that's actually why I said we had mixed feelings in the beginning, but our fears began to grow. Morocco and the Court of Cassation had a chance at that time to drop everything, to drop the proceedings, because China submitted the formal extradition request later on. And that's actually, when we had our fears began to grow. And then there were several hearings before the Court of Cassation, during which the lawyers insisted on the risk, on the situation in China, on the personal risk faced by Idris. They invoked Article 721 of the Code of Criminal Procedures. This provision in Morocco is not perfect, but it explains that an extradition can be refused when the request is politically motivated, when there is a risk of discrimination based on race, religion, nationality, or political opinions, and that may negatively impact the situation of the person. So this provision is the best you can get. It's not exactly in line with Article 3 of the Convention Against Torture, but it made sense then for the lawyers to mention it and to argue that it would be against this provision to proceed with the extradition. But despite the high quality of the defense, the quality of their pleas, the Court of Cassation ruled in favor of the extradition on December 15, 2021. And I must mention that the decisions cannot be appealed. The final decisions on the implementation of the extradition lies in the hands of the Prime Minister. And as far as we know, Aziz Hanouch, the Moroccan PM, did not sign the extradition decree, which is, a promising sign. But nonetheless, the court approved the extradition. And as soon as we heard about the decision of the courts, in our rights group and Safeguard Defenders, we requested the urgent intervention of the CAT. And 5 days later, it was a bit long, but 5 days later, the CAT requested Morocco to take interim measures by suspending the extradition of Idriss pending the review of his case. Morocco de facto complied with the request from the CATs, but has taken very little steps to improve the situation of Idriss Hassan. He's still in prison. Morocco also, there was an interaction between the CATs and us, and Morocco claimed that Idriss, the complainant, failed to exhaust the domestic remedies because he didn't introduce an application for revocation. It's a little bit technical, but this remedy doesn't have a suspensive effect. So we argue that it's not an effective remedy. So it's now clear that it's been 2 years now that we obtained this decision from the CAT. We are waiting for a decision of the Committee Against Torture, a final decision on the case. And it's clear that Idriss will remain detained in Tiflet as long as the case remains pending before the Committee Against Torture. His asylum case cannot be processed because the UNHCR does not have access to, they cannot conduct the refugee status determination in prison. And Morocco itself, they know, and in previous cases, they urge actually the CAT to expedite the issuance of the decisions because they know that there is a lack of provisions, legal provisions allowing the detentions order to be lifted. So now our priority with Safeguard Defenders is to make sure that the CAT issues a final decision as quickly as possible. We'll also make sure that Idriss is treated well in prison. For a long time, he was subjected to solitary confinement. And yes, and then what we are hoping, maybe that's more our perspective from at MENA Rights Group, but we are hoping that the decision of the CAT will also recommend structural reforms in Morocco. Morocco should introduce an appeal process in the context of extradition proceedings. And also the Code of Criminal Procedures should be fully in line with Article 3 of the Convention. Maybe a few words, if I have the time, about the role that could be played, as NGOs to fight, to counter transnational repression. Obviously, it's very concerning that Interpol played a key role, in the arrest of Idriss. It led to his 2-year plus detention. It's also very concerning that, as Laura mentioned, that it took Interpol 4 years to review the information contained in the Red Notice. But as NGOs and Ben Keith, I know that you're aware with the proceedings, but subjects of Interpol Red Notice can also appeal to the Commission for the Control of Interpol Files. But I must say that it's a very timely process. I think it takes 4 months to make sure, to have the information if your name is included in the database of Interpol, and it takes another 9 months for the Commission, for the CCF to decide if the Red Notice should be, or the diffusion should be cancelled.
On that,
yes, please. Yeah.
We know from Interpol's timescales that they say that they will give you a decision on whether they hold evidence against you within 4 months. My experience and experience of many of my colleagues around the world is that that's something they usually meet, but it's not always. And then the 9-month decision for the Commission for the Control of Files, which is the semi-external body, which is effectively the review process, is meant to be done within 9 months. But our experience, again, is it depends very much on the case. 9 months is a sort of aim of Interpol. And I think, as I've said many times before, one of Interpol's major problems is that they lack significant funding or significant oversight. And so they are in no great rush to remove red notices. And so if you try and remove a red notice, it is 9 months minimum. And that's providing your lawyer can send the letter on the same day. And in reality, as you said, you can't just send a letter saying, this is a Chinese case, ignore it. You have to provide evidence. That takes time to gather. You have to provide detailed submissions and sometimes expert evidence to show what risks a particular individual faces. And so all of that, 9 months is the sort of, it's more like 10 to 12 months from when you discover that there's red notice to when it might be removed. But there are some procedures on the interim. If you are detained, Interpol has been known to work much faster, but even then, by that stage, it's too late because, as in Idris's case, once you're arrested and detained in the country where you are, Interpol has said in that case, well, it's not our problem anymore. I know that the Sky News podcast interviewed Idris's family and Jürgen Stock about that case, and the response was essentially that Interpol was no longer involved because it was a Moroccan issue. So, yeah, thank you. Did you have anything else to add?
Yeah, no, I mean, if the red notice cannot be lifted in time, I strongly advise, everyone, NGOs or legal representatives, to request interim measures from the Human Rights Committee or the Committee Against Torture, or when applicable to the European Court of Human Rights. We know the capacity issues of all these committees. It's also a lengthy process, and yeah, while awaiting a final decisions, like the case of Idris, the person might stay in limbo, and it might lead to indefinite detention, which is the case for Idris. But that's it on my side, and I also wanted to maybe, like, as a concluding remark, to thank Safeguard Defenders too, because we've been working on that case almost from the beginning, and also the Moroccan lawyers who did outstanding work when the case was pending before the Court of Cassation in Rabat. Thank you very much.
Well, thank you very much, Alexis. Our final speaker is Luc de Pulford, who is the executive director of the Interparliamentary, and I think the founder of the Interparliamentary Alliance on China. And Luc has recently been subject himself, not recently, but over the course of quite a considerable period of time, being the subject of transnational repression, not obviously because of being a Uyghur, but because of your campaigning work, both for the Uyghurs and to show the repression of the Chinese state. So, Luc, perhaps you can give us a flavour of other sides of transnational repression and where you see the future taking us.
Thank you very much indeed, Ben. It's a generous introduction, and I do want to say, first of all, that the experiences that I've had are in no way comparable to the experiences of dissidents from the Uyghur or the Hong Kong communities. They are irritating, they are unwelcome, but it's an entirely different level of repression suffered by dissidents, particularly in the UK, from those communities. And I wouldn't want anybody to think that I compared my experiences to those. So I'm standing in for Baroness Kennedy inadequately. I actually saw her last night with a whole bunch of other sanctioned MPs. It was the first time that we'd had all of the sanctioned parliamentarians together for a meal. And we realised during the course of the meal that each of us had been warned of extradition to the PRC or to Hong Kong from anywhere that had an existing extradition agreement. That was about the only thing that connected us, because we weren't all sanctioned. I hadn't been, to my knowledge, I don't think I've been personally sanctioned. But we were all warned by the Foreign Office of the possibility of extradition to the PRC and to Hong Kong. So that obviously connects very strongly to this brief. And I was asked to sketch out some of the transnational repression faced by the Hong Kong community, particularly in this country. As I think most people on this call will know, yes, Uyghurs for a long period of time in the UK and beyond have suffered intense transnational repression. But many of those techniques and some new ones are now finding their way into the Hong Kong community in the UK and elsewhere too, including, as Laura set out, recent bounties imposed upon the heads of a number of Hong Kong dissidents living abroad. So I just want to quickly try to chart the degradation in Hong Kong's freedoms, because I think it's sort of useful to get into how we might talk about the abuse of Interpol. Hong Kong, not so long ago, was considered a rule of law jurisdiction. In fact, having a legal system that was respected and enjoyed all kinds of monikers as a jewel in the crown of legal systems in Southeast Asia. Those rights and freedoms underpinning the rule of law in Hong Kong were supposed to be protected by the Sino-British Joint Declaration, which had as its implementing legislation the Hong Kong Basic Law. I think everybody knows now that post-2019, the big protests in Hong Kong and the imposition of the national security law is certainly regarded by the UK as a violation of international law. The Sino-British Joint Declaration, which was supposed to safeguard the way of life and the autonomy, the relative autonomy of the people of Hong Kong. I think the best illustration of this degradation in the rule of law is a trial which is currently before us, the trial of Jimmy Lai. Jimmy, as I'm sure you all heard, is a very wealthy Hong Kong media magnate. He's a billionaire, made his money, self-made man, through various media organizations. He's always been pro-democracy, and he's a pretty elderly man now. I mean, he's in his late 70s. I think he's 76 or 77. And Jimmy, among a number of other names in an older generation of pro-democracy activists in Hong Kong, had always peacefully campaigned for universal suffrage in Hong Kong, and was one of those people who was around when the handover was happening and the legal settlement was being, the constitutional legal settlement was being negotiated. Now, quite important to understand about what happened in Hong Kong is that the younger generation, who were principally behind the 2019 protests, thought that that older generation, including Jimmy Lai, had failed in what they had managed to secure for Hong Kong. And the reason this is important is that Beijing, in this trial of Jimmy Lai, which is happening as we speak, in this trial, they want to try to paint Jimmy as the mastermind behind the entire Hong Kong pro-democracy movement. That in itself is an absurdity for anybody who knows Hong Kong, because what I've just described, you've got a younger generation who didn't actually like the way that Jimmy and people in his generation had gone about campaigning for democracy. But Beijing wants that. They want to be able to say there was a mastermind behind this whole thing, that there was a sort of sleeper for US foreign interests in Hong Kong who was the puppeteer of all of these young people, these millions of people who took to the streets in Hong Kong. Now, the problem for Beijing in securing this narrative around Jimmy is that there is very little evidence to connect Jimmy to the younger movement, the predominantly youth-led movement in Hong Kong. So what they have done in order to try to close that gap is to force some of those people in the younger generation to testify against Jimmy Lai in his trial, and to say, effectively, Jimmy made me do it. Now, that includes one man called Andy Lee. Andy's very well known to a lot of international legislators because he did a little bit of international organizing around Hong Kong in 2019. Andy tried to escape Hong Kong with 11 others after he was arrested under the national security law in 2020. Andy was taken to Shenzhen prison in mainland China, and Andy was reportedly tortured while he was there. After that, he was returned to Hong Kong, and very soon after his return to Hong Kong, he appears on the witness list against Jimmy. Right, so just to be clear about that, because I know these things can get very convoluted, Andy, who had done international work, speaking about Hong Kong with international legislators, was taken to mainland China, mistreated in prison there, and is now agreeing to testify against Jimmy Lai to try to make out that Jimmy Lai was the big mastermind behind the 2019 movement in Hong Kong, the disruption and unrest in Hong Kong. So that is how Beijing is attempting to secure its narrative around Jimmy the mastermind. So say all of these younger people, but Andy's confession is a coerced confession, and it's a confession that has occurred after very credible allegations of mistreatment in prison. So I explain this story just to illustrate the state of the rule of law in Hong Kong. That's what's happened to the place. The national security law has enabled this kind of treatment, created the conditions for it. Now, the national security law itself is extremely vague. Not only does it create the conditions for the treatment of Jimmy, it creates the conditions for the misuse of Interpol. In 2020, two of our Danish co-chairs within the Interparliamentary Alliance on China, we have politicians who act as co-chairs for the particular country, and they're normally one from two of the main political parties in that jurisdiction. So the two Danish co-chairs, who were at the time somebody called Katarina Amitsbøl and Uffe Elbæk, they invited a Hong Kong legislator to come to Denmark, a guy called Thiry. Well, they sort of manufactured an invitation to come and speak at a Danish parliamentary event. Ted came and then never went back to Hong Kong. The Hong Kong authorities were very upset about this. So they tried to issue red notices, not just for Ted, but also for Katerina and Uffy. And well, in fact, they made a formal request to the Danish authorities to cooperate with the police in Hong Kong, which, to the credit of the Danish authorities, was rejected. But I set this out just to illustrate how the vagueness, how the lack of understanding of the national security law, and how the lack of grasp of what it might mean legally can create a situation where some foreign countries might cooperate with the law thinking that it's legitimate. Anyway, the Danish authorities did the right thing in this case. But I think Jimmy and Ted's stories alone are sufficient to illustrate the depths, sadly, to which Hong Kong has sunk. And my own story comes into it because one of Jimmy's charges is collusion with foreign forces to undermine national security. So if you're going to collude with foreign forces, there have to be some forces with which you've colluded. So I am named as one of the co-conspirators with Jimmy on that charge, along with Bill Browder and my Japanese colleague, Shori Yamao. We think that formal legal designation will mean that if Jimmy is convicted, there may be further consequences, and that may again engage Interpol. Let's see. I do know, well, I have made a formal request to Interpol myself to see whether or not there has been any attempts to date, and I know that Bill has done the same, but we'll have to wait and see. Without telling too much of a sob story, I think it just means for people like me that we have to be a bit careful about the countries that we go to. There are certain countries that are a little bit closer to the PRC. Well, the relations with the PRC might be more intertwined or dependent, where we do have to be a bit more careful, or at the very least, take precautions before going. So there's a certain amount of looking over your shoulder. I don't want to go on too long, really, particularly after strong presentations from people who know much more about Interpol than me, but I would want to add, in addition to some of the recommendations made by others, especially those actually regarding extradition agreements, that we did make a request to the Minister for the Asia Pacific in the UK, Anne-Marie Trevelyan, last week, that the UK establishes some kind of early warning procedure where they anticipate politically motivated abuses of Interpol, and that they ask for a proactive search to be made of those names, and for those names to be flagged as potentially abuses of the system. Now, the minister did not agree to that in this meeting, I hasten to add, but she did agree to look at it. And I do think that it's something that could give those of us who might be pursued unjustly some peace of mind. So that's my bit. Thank you.
Thank you very much, Luke. We've got a few questions that have come in, but I had one just to start with, which was really in relation to what you've just said, Luke, and I know Laura knows about this as well, is that we have a situation at the moment, to my understanding, that there are in fact quite a number of extradition treaties with other European states. And I've dealt with cases in France and Italy, and a few other places. And we know that after the European Court of Human Rights decision in Liu, that in fact there have been, I don't think there have been any extraditions to the European Union, but there has in fact been quite a lot of extradition activity. And so places like France and Italy, although the risks of extradition are low, the risks of arrest are actually potentially quite high. I don't know whether either Luke or Laura might have some other insights into people who are facing problems in European states.
Yes, thanks for raising that, Ben. Absolutely. So since the Liu versus Poland decision of October 2022 by the European Court of Human Rights, we haven't seen any approval of an extradition to China. Obviously, that sentence, clearly states that the court determines there's a general situation of violence in China's penitentiary system, among other things. So basically barring any extradition to China moving forward on the basis of Article 3 of the European Convention. However, cases are ongoing. So there's been, I think, 2 or 3, no, maybe even more sentences since in various European courts across European member states. They've all denied the extradition. 3 of them have been in Italy, actually. But cases are ongoing. There's now a case in Spain that's coming up, which will be the kind of first test case, you know, of the European court sentence in Spain. Obviously, we're hopeful that Spain will uphold that pilot judgment, but you know, you never know, and you have to go through it. And I think one of the things that's important in that regard as well is that the European Court of Human Rights made a second determination in that Liu versus Poland sentence, stating that they condemned Poland for arbitrary detention, so violation of Article 5, paragraph 1 of the convention as well, because the judicial proceedings between the moment when the person in Poland, Liu, was first arrested, and by the time, you know, the whole judicial proceedings were through, he had been arbitrarily detained, spent too much time in prison. And obviously that's an ongoing risk for people that may be, you know, targeted by these kind of measures, because by the time a judicial proceeding is through, they may have spent a considerable amount of time in prison, in home arrests, or otherwise have been deprived of their liberty. And obviously that's part of the tactics of the People's Republic of China, right? The Chinese authorities, even if they can't effectively get someone back through extradition, they themselves have said it's becoming increasingly slow, it's increasingly cumbersome. As they stated, they use that as an excuse to use extrajudicial methods. But they still use it, as you said, not only actually to locate someone, but also as a kind of, if you will, interim punishment or interim limitation. And that's something that activists have decried over all these years. I mean, it's the climate of uncertainty. You never know, because it's true that there's measures, you know, maybe you can request Interpol to say what information's in your file to rectify things, but most people don't even know they're on a list, right? Most people don't know they're at risk. And so it creates this continuous weird limbo where maybe your foreign ministry warns you of traveling to countries with extradition treaties, but they can't actually tell you whether you're really at risk. And once you get there, you're also not sure. It very much, I think, at this point depends on the profile of the individual, whether you'll be arrested, how much time you might spend in jail, how much other limitations you might encounter. So it's ongoing, and that's why as Safeguard Defenders and IPEC as well, sorry, Luke, I'll just say it, we very much continue to, you know, advocate for a political solution, which is the suspension of all these bilateral extradition treaties. Because having established that you can't extradite anyone, why would we need to politically continue to legitimize, give prestige to, you know, the Chinese judicial system, which is clearly in violation of our all international human rights standards?
Thank you, Laura. Luke, you can respond as well.
Yeah. Just briefly to say that, well, government's very complacent about this. So in my latest meetings with the Foreign Office, they said to me, they'll never do it. They'll never do it. It would be such a huge escalation that they wouldn't even dare. And I thought to myself, well, easy for you to say, you know, we wanted a little bit more support than that. So there's a lot of complacency around it within government. Yeah, we could debate why that is, but that it is beyond question.
I mean, what I find extraordinary is that, I mean, for instance, in France, is that they suspended the Hong Kong extradition treaty because of the issues that you might then be referred onwards to mainland China. But then moments later had signed a full extradition treaty with China. And whilst they've not actually extradited anybody there, the 2 extradition requests, I think it's been 2, there may be 3, which have come from China, have been discharged. But those individuals were, I know, at least one of them was detained for a number of days pending that, and then the fight wasn't days, it was months. We've got some other questions. A couple of which have been answered in writing, but I will come to them. One from Ted Bromond in relation to the Uyghurs. Are the Uyghurs persecuted when they're persecuted through Interpol or extradition? Are they largely facing terrorism or national security offences, or does the PRC use other charges? Rahima, I suspect that you have more knowledge of this than anybody, but
yeah, most common so-called crimes, terrorism or separatism. For example, I think for people to know more about, you know, the historical way that the Chinese government abusing the Interpol, is this book, China Freedom Trap, written by Dolken Isa, the president of the World Uyghur Congress, and he was on the red notice for many, many years. And you will be able to understand from this book quite in depth of how Uyghurs are targeted. This is not new. And I also know quite a lot of friends who never involved in anything apart from just giving evidence about what is happening inside China, that they found their name on some of the lists, like terrorist lists, in this leaked file 2 years ago, Shanghai, we call it Shanghai file or Shanghai terrorist lists. So it is very easy for Chinese government to just make up a lot of crimes, the so-called crimes, or any involvement. Whenever there is some protests, even including like 2009, the Urumqi massacre, and I was blamed all the leaders of the World Uyghur Congress and or the like a mastermind behind these protests. It's very similar to what is happening in Hong Kong as well. This has been like a very historic.
Thank you. I mean, one thing that we're not going to deal with the other Chinese transnational repression too much, but there is another strand of Chinese transnational repression which I've seen, which is the targeting of anybody who is considered to be anti-Chinese Communist Party, and that can be due to public profile, due to westernization through wealth, or just living outside of China for too long. I don't think what we've seen a lot of, but I'm sure the PRC will get to it, is what they often do in Russia and other states, which is just to manufacture a charge that is completely unrelated to national security or terrorism, and use that as a stick. And what's very concerning, Rahima, is obviously if the direct allegations against Uyghurs are national security and terrorism charges, that Interpol are even considering those as possible red notices, because that, I mean, there's not even an attempt to hide that. We've had a couple other questions which I know have been answered partly in writing. I'm just going to quickly run through them. We had a question from Ewan Grant asking which countries are cooperating with the Chinese notice requests, and which countries are slow in getting ready for accelerated Chinese, Russian, Iranian, and Venezuelan hostage taking. Laura, would you like to answer that? I know you've answered in writing briefly, but for everybody who's here.
Yeah, very quickly, because obviously it's a big question and it's a very mixed bag, I would say, of responses, of awareness. I think over the past years, we've definitely seen growing awareness in, let's call it, Western democracies in general on the risk associated with, Interpol abuse by authoritarian states such as China, but not only China, and other forms of transnational repression. So we're kind of slowly starting to see, I would say, a response, especially when it comes to, for example, Interpol abuse across Europe. Obviously, US and Australia seem to be way more ahead of the curve when it comes to tackling the wider issue of transnational repression. Canada has been catching up, or at least wants to catch up. I think the UK kind of wants to catch up. We're still waiting for some concrete measures and what will happen there. But so there is a growing awareness and some initial action. In the rest of the world, two things. One, countries may not be aware of things, but maybe more importantly, obviously, China has been very heavily investing in many of those countries. Many of those countries themselves may not exactly have democratic regimes, and so they're quite keen to cooperate, do law enforcement cooperation without too much regard for human rights and other concerns, or even judicial sovereignty for that matter. So it's a bit of a mixed bag of responses. I think we're still very far away from a comprehensive and kind of coordinated response, even across democracies. Again, anecdotal evidence suggests that also when it comes to dealing with certain Interpol red notices, for example, coming from certain states. European member states are being more cautious, may choose to act or not act. Again, it seems very arbitrary. There's no real official policy. But so things, I think, are moving a bit. Ben, if you'll allow me, I just wanted to quickly also add something to the question before, because Rahima is absolutely right when it comes to, Uyghur people that are being targeted by official police or judicial cooperation mechanisms. Terrorism, separatism, those kind of charges are the most used. But I would say in general, the vast majority of charges that the Chinese use against any target abroad is really economic charges, right? Fraud, economic crimes, and so on. And we have some very interesting sentences. I was just reading one from France, for example, from last year, where it's very clear that they use those charges as an excuse to bring the person back to then kind of testify as a witness against a high party official who had fallen in disgrace, for example. That was one example. So there's actually evidence of how those mechanisms are being abused. But again, it is a charge that may resonate with law enforcement overseas. And it's not just dissidents, it's not just critics. We increasingly see it's really everyone, is at risk coming from China. In particular, these days, I would say also state employees or employees of state-linked companies. Just at that.
Thank you, Laura. Alexis, you've got your hand up as well.
Yeah, no, thank you. I just wanted to add something in relation to Yuan's Grant's question about maybe the link between the MENA region and transnational repression. I just wanted to mention, I checked the extradition treaty signed by the Arab League member states and China. And there is obviously Morocco, Algeria, Tunisia, and last but not least, the UAE. That's maybe the list is not exhaustive, but that's the list that I know. But more treaties might be concluded, maybe with Saudi Arabia. It's something that should also be monitored very closely as well. Maybe something I wanted to add in relation to the extradition treaty. In most extradition treaties, it's quite highlighted that the extradition should be refused when it's politically motivated. But it's up to the state to decide if the crime is political or not. And clearly, in the case of Idris, Morocco's courts decided that he was not wanted for political crimes, despite all the evidence provided by the lawyers. He was wanted for terrorism, and this didn't fit in, the definition of a political crime.
And I mean, from a legal perspective, there are huge problems in international law with what the definition of a political crime is. The definition of political crime in lots of different treaties is in there, but some states consider a political crime to be effectively a crime committed whilst you're a politician, or an election fraud, or something that is actually a crime that is centered on the politics. Whereas other states, particularly those who have strong refugee convention history and case law, it's a much broader topic in that it's not a political crime as such, as a politically motivated crime, and it's very difficult to distinguish the two. I mean, I think my answer would be that there's a lot of sort of sleeping problems. We see European states signing treaties with China, and I know Laura's talked about some countries that who she thinks are doing a good job, but behind the scenes, I've seen in immigration cases, which are sort of often behind closed doors, that some Western states and some states which follow democracy are looking at Chinese red notices and saying, well, hang on, you're accused of a crime in China. And so that's enough for us not to grant you nationality, not to give you a visa, not to allow you asylum. You're excluded from the Refugee Convention because you have this Chinese red notice. And then it's another way of stopping people becoming settled or protecting themselves. I've got one fun question, which is a sort of technical question about how to remove red notices. I mean, very quickly, Abbas, firstly, there's quite a lot on the Red Notice Monitor website if you'd like to go there, but really the only way to challenge red notice is to write to the Commission for the Control of Files, requesting that they remove the red notice on a number of different grounds: political motivation, failure to observe human rights. But you have to provide quite significant amounts of evidence, sometimes expert evidence, and technical know-how as to what a particular individual faces. It's not usually good enough to say, well, it's China, so you can't issue a red notice. Although as one of the things that we have been discussed, is that there are several states, China being one of them, that really should, in my opinion, have much higher scrutiny. Well, thank you all for speaking today. It's been fascinating. I know that hearing the stories of what's happened to people can also be very difficult. Thank you for giving all your insight and experience and expertise. I know there were some people who weren't able to attend. This will go out on social media and YouTube, was the recording. But I'd like to say thank you very much to all the panelists, and I hope to see you in person very soon. Thank you.
Thank you. Bye.
Bye-bye.
Thank you. Bye.